Hello friends, in the series on income tax cases, today we will discuss a very important case which is based on CBDT Instruction No. 1 of 2011 dated 31st January 2011. The issue before Delhi ITIT SMC bench was that if the notice under section 148 is issued by the Deputy Commissioner of Income Tax, where the income of the assessee is only 4,75,478, and according to the instruction number 1 of 2011, if the notice is to be issued by the assessing officer, so whether in that case that assessment is valid even if the assessment is done by the National Faceless Assessment Center or by the other assessing officer. This issue has been decided by Delhi ITIT SMC bench in the case of Deputy Commissioner of Income Tax versus Alaka Marks Private Limited, and this case is reported in 136 ITR Tribunal at page number 1. The date of the judgment is 21st January 2026. The present case relates to the assessment year 21-22. In the present case, the notice under section 148 was issued to the assessee on the allegation that the assessee has received an accommodation entry of rupees 10 lakh from the entry operator. The assessee raised the objections, and when the assessment was going on, the assessee submitted all the documents, but the assessing officer did not make any inquiry and made the addition of rupees 10 lakh under section 68 as unexplained credit. The assessee was contesting the case by saying that since the amount has been repaid, and the assessee quoted a number of the judgment where the additions have been deleted just on the basis that since the amount has been repaid, so it cannot be presumed that the assessee has taken accommodation entry. But the AO went with the addition which was deleted by the learned CIT appeal on the ground that since the amount has been repaid, so the addition under section 68 is not justified. The revenue challenged the order of the CIT appeal even if the tax effect was less than 60 lakh because the amount of the addition was just mere 10 lakh. The appeal of the revenue was admitted because the revenue was taking the shelter of the circular by saying that it is a part of the organized crime, so the limits do not apply for the case of the assessee. When the matter was being heard, the assessee again raised the point that in the present case, although the assessment has been done by the central circle, but the initial notice has been issued by the Deputy Commissioner of Income Tax, while the income of the assessee is only 4,75,000, and it is in violation of the Instruction No. 1 of Central Board of Direct Taxes, which is of 2011 dated 31st January 2011. And when this point was raised before the tribunal, once again the tribunal was convinced and the tribunal quashed the assessment proceedings by saying that in the present case the notice has been issued by a non-jurisdictional officer. Friends, this case is very important, and in addition to this case, I have to say that the income of that year is to be taken or is to be considered for which the assessment has been reopened, not at the time when the notice has been issued. For example, in the present case, the case was relating to the assessment year 21-22. So the return income of 21-22 is to be taken for deciding whether the notice is to be issued by income tax officer or by the assistant or deputy commissioner. The other point is that when the assessment of the assessee is being completed or in the central circle, then this instruction will not apply. But if the notice is issued by non-central circle, meaning thereby that the case of the assessee is not centralized, and at that time the notice has been issued by deputy commissioner in spite of income tax officer, but the case is being transferred to the central circle, then the instruction will apply, meaning thereby that when the original notice before transfer is being issued by an officer which do not have the jurisdiction as per the instruction number 1 of 2011, so that notice is bad in law. At the end of this video, once again I am repeating the name of the case. The name of the case is Deputy Commissioner of Income Tax versus Alaka Marks Private Limited, and this case is reported in 136 ITR Tribunal at page number 1. and the date of the judgment is 21st January 2026. Thank you, friends.